proceed. As indicated from the calendar, we have 3 cases set for oral argument today. The first case, Percell Shaw, deceased, versus Associated Grocers of Florida et al.
Good afternoon. May it please the Court. Jay Levy on behalf of Annie Harrison as personal representative of Percell Shaw. Respectfully request 3 minutes for rebuttal. Your Honor, this case involves the procedures by which we substitute parties in a workers' compensation case. The Judge of Compensation Claims below applied Civil Procedure Rule 1.260 to effect the substitution, found that there had been no compliance with the rule, and consequently dismissed the claim. In addition to dismissing the initial claim, which was filed by the claimant before he became deceased, he dismissed a second claim brought by the personal representative. We seek review of both of those rulings in this particular case. There is no dispute that, what happened in this case is fairly simple. There was a hearing in October of 2002, at which point it was admittedly discussed on the record that there had been the death of the claimant. And the Judge of Compensation Claims at that time ordered that there be a substitution of counsel, a suggestion of death, thereby implicitly recognizing that there had to be a suggestion of death filed. It is beyond dispute in this record that there was none filed within the night, and eventually it was not filed until, I believe, March or April of 2003. At that point in time, there was no substitution made within 90 days, and eventually when the motions came on to dismiss the claim, claimant's counsel first indicated on the record in at least 2 different hearings that he had never received it, and then filed an affidavit under oath saying that he had never received it. We bring 4 issues before this Court today for consideration. The first is whether Florida Rule Civil Procedure 1.260 applies. I would be remiss if I did not say that my opposing counsel has pointed out in his answer brief that we did not raise this below, and as I indicate in reply, I've looked carefully through this record and it was not raised below. Nevertheless, I would suggest to the Court that it is a type of fundamental error since it represents the crux of what the trial court did. But even if it would not be considered fundamental error, in some manner this Court is going to have to author an opinion at some point, whether it be in this case or another case, as to the procedure for substituting a party. Now, opposition has pointed out in their brief that there is no procedure for substitution, and therefore I believe they go on to argue there should be no substitutions allowed in workers' compensation cases. This Court has decided many, many cases, and I would cite to the Court its decision in BEC Construction v. Gonzalez, Right-Way Windows v. Robbins, both of which are cited in my brief, indicating there can be substitution. So it's not an issue that you can substitute parties in workers' compensation cases. Those cases are replete in the case law and go way back before this Court to the Florida Industrial Commission. So the question is, how do we do it? We have posited in our reply brief, and I think correctly so, that we admit that no judgment or order could ever be entered against a decedent, because once you're deceased, you cease your attorney-client relationship, and I think that's the logic of both of the cases I cited to the Court today. However, we think that up to and including final order, a substitution can be effectuated upon the filing of a motion. This Court, in the Robbins case, a case that I had the pleasure of arguing to this Court, only dismissed the claim with prejudice for leave to go back and appoint an appropriate PR, but indicated that the claim did not have to be relitigated. So I would suggest to you respectfully that there is a basis to have substitutions in Florida. I would respectfully suggest also that under, I believe it's the Farrell v. Amica insurance case, there has been no rule ever promulgated to apply Rule 1.260 to workers' compensation cases. And absent promulgation of such a rule or incorporation of such a rule, that rule simply does not apply. With no disrespect meant to the learned judge below, he made up the procedure as he went along. And
well, that 1.260, I believe, was first suggested by counsel for the claimant, wasn't it?
You know, I don't want to misrepresent anything, Judge Allen. I don't remember how it came up, but my recollection is that it came up from the judge. The judge, but I'd have to go back and look, and I'll see if I can't do that while Mr. Taylor's arguing, because I don't want to misstate it. But I think it came from the judge. The judge was the one who came up and suggested it. But I do know that it was never disputed below that it applied, and I don't want to represent anything else. But I still think that this court would need to consider what would be the appropriate procedure for substitution in a comp case. And to my knowledge, in the research that I've done, there is no such case that talks about the procedure. The second point is that even if 1.260 applies, the judge did not comply with the procedure, because the judge, in his desire to find a 90-day period, made two findings which have no support under the case law for 1.260. First, he found that at the original hearing in October, we had actual notice, and therefore, since we had actual notice, that triggers the 90 days. And he said if you didn't have actual notice from that point in time, well, then you had notice of the appointment of the personal representative. And that's another trigger for 90 days, and admittedly, under either of those theories, we're out because we didn't file within 90 days. But the problem is the language of the rule. 1.260 says, in quoting in part, unless the motion for substitution is made within 90 days after the death is suggested upon the record by service of a statement of fact of the death in the manner providing for the service of the motion, the action shall be dismissed as to the deceased party. Again, with no disrespect to the judge below, that requires a writing. And the rule is what it says, and it requires that there be a suggestion of death filed in writing. That, the actual notice does not trigger it. The notice of the appointment of the PR does not trigger it. Only a written suggestion of death triggers this, and that was not done here. So the judge's interpretation of 1.260 is wrong. Even if this court were not convinced by that, we get to the third point. Counsel filed an affidavit. I never got it. He told the judge on 2 occasions, representing as an officer of the court, I never got it. We think that this issue is decided by this court's decision in Abrams v. Paul, a similar situation. In that case, this court held that the certificate of service creates a rebuttable presumption that it's been received, but a denial is sufficient to overcome the presumption, at least to get a hearing. Now, once the judge has the hearing, he weighs the evidence, he decides who he believes. It may not be sufficient. The court may find that there could be evidence, for example, a process server specifically went to the house, and the judge may believe that. He may not believe the lawyer, but in terms of this law's case law, and we believe the Abrams case is positive here, that's all he had to say under oath to rebut the presumption, at least to get the evidentiary hearing. The judge refused to hold an evidentiary hearing, and at the very least, we would be entitled to an evidentiary hearing to determine whether we ever received the certificate, the suggestion of death. Lastly, and most curiously, assuming everything the judge did was correct, assuming that he properly dismissed his claim, there was another claim filed by the PR directly, and I don't know why he dismissed that claim. Because the dismissal for suggestion of death for failure to comply within the 90-day period can only be without prejudice. It's not an adjudication on the merits. And even the rule says that it shall be dismissed as to the deceased party. Well, the deceased party was dismissed, but it doesn't say that the representative party, the PR, cannot file their claim later. But the way the JCC handled this case, he used a broad brush. He wiped out everything, and he said, you can't even file this other claim. Now, I don't know whether that claim is barred by the statute of limitations. I don't know whether there are bona fide defenses to that claim. But that's not the issue. The issue is whether we could file the claim and proceed on that claim. If there are defenses to it, you file your defenses. The judge has a hearing. But he didn't do that. He just took this claim and he wiped it out. And assuming that he could dismiss the claim of the claimant because there had been no substitution, he was not entitled to dismiss the remainder of this new claim brought by the PR. So for all those 4 reasons, for the fact that 1.260 is not applicable to these proceedings, but if it is, the judge didn't follow it. And if he did follow it, he had to hold an evidentiary hearing with regard to whether we had received it or not. And if he did all that right, he still couldn't have dismissed the new claim brought by the PR. We respectfully request that you reverse the order of the judge of compensation claims and remand this case for further proceedings. Thank you.
Mr. Levy,
Yes,
there was an appeal of an earlier order in this case.
Yes, Your Honor.
On an order back in 2003, and in comparing that order, which was, I guess dismissed by this court because it was non-final.
Yes, Your Honor.
With the dispositive language in the current order, I'm having some difficulty in seeing a whole lot of difference. I mean, it looks to me like the judge in both cases simply granted a motion to dismiss rather than actually dismissing the petitions. Could you help me see what the difference between the two is?
I'd have to go look at it because that's not been raised in all candor. But my recollection is that this order goes farther than the other one did. I was counsel in the other one. It was only dismissed. But this one now has, I'd have to go look at the language because that's not been raised in any of the briefs.
There was a show cause order in this appeal, which was, I believe, discharged. Am I correct about that?
I'm sorry, Judge, I didn't hear you.
I believe a show cause order issued asking why, because it appeared that this may be a non-final order.
I believe that I responded to that at some point in time.
And you responded that show cause order was discharged.
That's my recollection, but
I do share the same concerns that Judge Allen has mentioned. If you would check, you're going to have a little time remaining, and so if you'll check that, the language in the two orders.
I would be delighted to.
Thank you.
Thank you, Your Honor.
Thank you.
Good afternoon. My name is Rayford Taylor, and I represent the employer carrier, the appellees in this case. I agree with Mr. Levy that there is the procedural issue that is intertwined with this case. And at some point in time, I do believe there will have to be some articulation of the rule on how parties get substituted in a workers' comp case. I respectfully suggest this is not that case. Employer carrier has a status conference in October of 2002 and says, Your Honor, we believe the decedent has died. Now, this is not a case in which the death of the decedent would trigger future benefits. There's no claim for death benefits here, and there's never been any assertion, to my knowledge, that there would be death benefits. These are for pending claims, old claims, back indemnity, that were the claimant still alive, those claims would have proceeded. He's deceased. Counsel for the claimant admits without any question on the record, I know the claimant is deceased. We've been advised that anyway. Judge says, well, I think you've got file a substitution, a notice of death, suggestion of death, and we need to get some substituted parties going here because under the law, the decedent's claims appear to be extinguished.
Under the workers' compensation law, what is the applicability of FAR Rule Civil Procedure 1.260 to workers' compensation proceedings?
Your Honor, before I answer that, I need to say that the consensus at that hearing was that the law is that when a decedent dies in a workers' comp case, those old claims cease to exist unless there's a substitution of parties. The judge says, well, under Rule 1.260, I think you need to get moving and substitute within 90 days. Arguably, as you look at it now, 3 years hence, it appears as though, strictly speaking, Rule 1.260 may not have, should have been applied because that's a civil procedure rule. It was never formally adopted into the workers' comp rule. Now, we have examples all through the case law of where the comp rules will sometimes borrow from the civil procedure rules. Now, that all changed with the new 60Q rules in December of 2004, but we're back in 2002 when this happens. So no one says, Your Honor, you can't use 1.260. You don't have the authority. Instead, the employer carrier asks claimant's counsel to file a suggestion of death. It's in the record. They don't do it. In March of 2003, they filed a suggestion of death. Now, counsel denies ever getting it. The judge got it. It's in the file. He says he got it. And so the argument being advanced all along was, until you serve me with a piece of paper, I, as counsel for the claimant, don't have to do anything. There are no time frames applicable to me. There's no rule you can't make me do anything. I can substitute whenever I want to. That's essentially the argument they advanced.
Do these new administrative rules address this situation?
The current administrative rules do not. No, sir. And I am not sure, I could not find, and we put in our brief, there is no specific workers' comp rule of procedure, which predated the 60Q rules, that ever specifically said, here's how you go about substituting a party. Now, they rely on the BEC case. Interestingly enough, the personal representative was substituted in that case. The court never discussed how they got to be substituted. We don't know whether they used the predecessor of 1.260 or how they did it, but they got it done, obviously. The other cases in workers' comp say you can't file a claim as the personal representative on behalf of a deceased claimant in workers' comp unless you have been substituted as a party. So clearly, the case law assumes that some timely mechanism will be triggered to get a claimant's PR, or appropriate authority, substituted for that claimant to preserve those old claims and let them proceed forward. Clearly, in this case, that didn't happen for over 14 months. And they go along, and in April of 2003, after being told that it doesn't look like they've acted timely if you use the October deadline, and I disagree with the idea that a party can't be made to pursue a substitution until they're actually handed a piece of paper. I think actual knowledge applies. So I think we can go back to October of 2002 and say that there was knowledge and 90 days should have begun to run then. But even if you don't use that date, the record shows without any question they knew in January who the personal rep was. They knew. And they had to know by March because that's when they got the letter from the lawyer saying, here's who the personal representative is. In April, they filed a claim with the decedent's name on it. Well, that's clearly a legal nullity. The judge in September dismissed the petitions without prejudice. There was the appeal, and that was assumed to be a non-final order. And therefore, the appeal was to show cause. It went away and went back and proceeded from there. In December of 2003, they filed a claim using the personal representative. In December of 2003, they filed that claim. They filed their substitution of party and their affidavit, essentially trying to establish excusable neglect. They go in for hearing. The judge says, I need you to explain to me why you think there's excusable neglect here. And the only document they have to work with, admittedly, is the affidavit, in which they dispute the filing of the suggestion of death. But, I mean, I don't really think they can hide behind that. They had an affirmative duty.
Well, would there really, other than the judge taking into consideration the certificate of mailing and the affidavit, no evidentiary hearing was conducted?
Your Honor, that's absolutely true.
Wasn't he, in effect, treating that certificate of mailing as almost a conclusive presumption of mailing, notwithstanding the affidavit, which seemed to suggest the contrary? And wasn't he required to conduct an evidentiary hearing on whether, indeed, that document had been mailed under the circumstances?
I don't think so under the facts of this case, Your Honor. And I say that because of the following. The judge, I don't think, he did accept the fact that it was mailed. There's no question about that, and did not give them a hearing on that piece. There's also no question that counsel for the claimant, and then later the personal representative, absolutely knew about the death of the claimant. So his position was, you have actual knowledge, it is on the record, and you had an affirmative duty to proceed with getting a party substituted in this case. And you have not set forth in your affidavit any facts which would entitle you to a hearing even on the issue of excusable neglect. Because when you look at the cases which have talked about excusable neglect, one of the cases that we cite in which a court dismissed a case, and the appellate court said, this court, in fact, in the Vera versus Aglin case, reversed and said you have to conduct a hearing because there was a question about the existence of the estate at all, whether there was one in Canada or in Florida or wherever it was supposed to be. You missed your 90 days, but we'll find that there was excusable neglect here for missing the 90 days. So therefore, you've got additional time to file your substitution. The second district, in a case called Cash and Carry versus Smart, said just because you don't know the name of the PR, that is not sufficient to establish excusable neglect. Because the way it should have worked under the rule, if you applied the rule, and again, there was no issue about whether the rule should or shouldn't have been applied, at least raised before the appeal. When you're not going to make the 90 days, you're supposed to file a motion for enlargement or extension of time and explain why you need additional time. And if you make good cause, you get that. If you don't make it, then you better have a very good reason why you can't comply with that 90-day requirement under the rule. The court said that since you didn't know the actual name of the PR, that's not sufficient to constitute excusable neglect. Well, that's clearly not the case here. They knew who that was. There was no timely motion here filed for a substitution or any sort of enlargement.
Well, it seems to me it's clear that if Rule 1.260 applies, that the suggestion the suggestion of death must, let's see, it has to begin, the suggestion of death, the filing of that, the record filing, it triggers then the 90-day time limitation, does it not, under the rule? In other words, that's the document of record that sets into play the commencement of that time.
I think, Your Honor, I think my personal opinion is it's putting it on the record, not handing a piece of paper to the judge. I don't think you have to stand there and read the certificate of death into the record to accomplish that same goal, Your Honor.
Well, if just assuming for the sake of argument that indeed that the suggestion of death is the document, the written document that sets into motion the 90-day requirement for substitution of party, and there is the party claims that he or she did not receive that suggestion of death, never received it. An affidavit is filed to that effect. Can the judge then conclude that that ends the inquiry at that point, and that without taking any evidence whatsoever?
I think it depends on what is alleged as the reason for why you did not timely act within 90 days.
Or an affidavit says never received that suggestion.
Well, Your Honor,
that's not excusable neglect. I mean, just prima facie.
I don't personally think it's excusable neglect. It might make if you want to treat it as a prima facie case, but you know what that means they're doing, Your Honor, under this set of facts? They're refusing to go look in the judge's file. There was a hearing in August when the petitions were the old petitions were first dismissed. And they had a whole conversation about this certificate of death and suggestion of death. And claimant's counsel said, I never got it, I never got it. The judge said, well, I did. So it was in the court file. They knew on August the 5th, without any question, there'd been a suggestion filed. And the fact they didn't even bother to get a copy out of the judge's file, they can't use that as an excuse now to stop the 90 days from running. That's just willful refusal, in my opinion, to deal with the facts in front of you, which is your client is dead. You've known since October your client was dead. You have a duty to substitute. The judge told you in October to file a suggestion in 30 days. They didn't do it. It's not our responsibility to do that. And when we did go and do it, they deny ever getting a copy of it. And with all due respect, under the facts of this case, I don't think that suddenly constitutes it doesn't immunize them from their duty to proceed with getting a substitution in place. Whether you use 1.260 or you use the judge's inherent authority to control their docket and ask and force them to do what they need to do, which is to timely substitute somebody. These parties, my client is now 3 years down the road, 3.5 now. Well, October of 2002, 4 years down the road, they're still litigating claims because they're here on appeal, and the only defense is, I didn't get a piece of paper, so I didn't have to timely respond, and I didn't have to timely substitute. And we respectfully suggest the rules don't operate that way, and that the judge, whether he was right or wrong to use 1.260 as the yardstick, he used it, and he went through it and explained in great detail why he thought every opportunity had been accorded. There was clearly no timely substitution by any standard.
Mr. Taylor, though, when you look at 1.260, it doesn't talk in terms of filing, it talks in terms of service. It requires service.
Of the suggestion of death or the motion for substitution?
Of the suggestion of death. And the assertion here is that that service was not effective. At least it was not received. And it seems that decisional law indicates that when that is suggested, that it's appropriate to have a hearing. And there was no hearing here. Now, I understand all the other things that you're talking about, which are very appealing, such as the indication the judge made at the time of the hearing that, look, I have something here, and they could have gone and looked at that, but whether they should have or not, and pretty clearly they should not have, they relied upon, and including the judge relied upon Rule 1.260. So it seems to me that if that's what you're going to rely upon now, then you have to take all of that rule, and all of that rule seems to require service, and the decisional law would seem to require hearing when there's an assertion that the suggestion of death has not actually been received.
Well, I don't necessarily disagree with that, Your Honor, but under the facts of this case, the only thing they can testify to at a hearing is, I didn't get the piece of paper, which they've already put in their affidavit, in which the judge found there was no facts other than their bare assertion to support that. And then he went through the other facts in their affidavit and concluded there was no excusable neglect and therefore dismissed. I see my time is up. Real quick.
So what you're saying, in essence, that a hearing would be simply an exercise of futility, is that?
Well, I'm not going to say the judge wouldn't approach you with an open mind. No, Your Honor, I'm not about to say that. But I am saying that he was faced with if the only assertion is I didn't get it in time, that's already been stated, and the judge concluded there was no proof to support that beyond counsel's bare assertion. And I don't think a hearing would be necessary in this case. I do want to say before I sit down, I think how we got to this point and this appeal is, I think the parties always assumed that this dismissal of the old petitions and the new petitions in the order that's under appeal was with prejudice. And the judge doesn't say that, but it would have been the second time the petitions would have been dismissed that the claimant filed, and I think that's probably why this has been.
But a dismissal under 1.260 is almost always without prejudice, isn't it?
That is true.
That's what the decisional law indicates.
But he dismissed them without prejudice in August or September of 2003, and they refiled them as the name of the PR. So our position would be that any dismissal would be the second dismissal and therefore would be with prejudice. But I understand your point, Your Honor. Thank you.
May it please the Court. Judge Allen, in response to your first question, at page 6 of the record, Judge Castillejo says, quote, has anybody filed a suggestion? You know what I'm talking about, a suggestion of death. And it goes on and he says, because generally what happens is one side or the other will file a suggestion of death. So the thought for the suggestion of death did not come from my side. It came directly from the judge. Second, I've compared the two orders. They appear at pages 48 and 130 of the record. It does appear to be the same language. It just says the motion is granted. I agree with my learned colleague. It should have said the motion is granted and the claim is dismissed with prejudice, but jurisdiction is a visceral thing, and I understand that. And if Your Honors, if Your Honors feel that that is fatal to this Court, considering the case, I would merely ask that you temporarily relinquish jurisdiction. We'll bring the appropriate order back. But Your Honor points out that under 1.260 it is without prejudice. I would suggest to you that it would be similar to a dismissal for lack of prosecution, and there are cases that those orders dismissing, that an order dismissing for lack of prosecution is subject to plenary review, even though it's technically a non-final dismissal. So I think under any one of those scenarios, Your Honor could hear this case. It's an interesting argument that would be made because, as I understand the rule, it requires a writing, it requires a filing, and it requires a service. The theory, if the judge meant for there to be oral notice and that would set you on the 90 days base, then why would he have said 90 days, go file your suggestion of death? If counsel is right and actual notice is all that is needed, there's no reason in the rule for it to say serve and file. And moreover, there was no reason for the judge of compensation claims to tell us to go serve and file a suggestion of death. He would have just said, you got your 90 days, it starts right now, go file it. argument that he makes, that Mr. Taylor makes today to this court, is directly contrary to the Abrams case, in which it said that we're obligated to get an evidentiary hearing. And let me, without meaning to, let me say that at this evidentiary hearing, it would be more than just necessarily the attorney's testimony. He could put in testimony as to his office practice. He could put in testimony as to the docketing system that they use. He could have corroborating testimony from and evidence from his firm as to what they do when these things come in. So we don't know exactly what the evidence would be adduced, and I would not want to speculate as to whether or not there would be more than just his mere affidavit. The only point we say today is his affidavit denying that he got it is sufficient to get the evidentiary hearing. And so respectfully, and lastly, we would point out, in this record, the first notice that we received, if you accept the proposition that counsel was correct when he said that he did not receive the suggestion of death, the first notice was in August of '03 when he received that, when he was told at the hearing that a suggestion of death had been filed. On September, 30 days later, he went and filed a new claim for the PR. Now, why they did that, I don't know. I don't know why they just didn't file the motion for substitute, which would have been within that 90-day period. But I would suggest to the court that the new claim constitutes the effective substitution in any event, and for that additional reason, it should have been dismissed. For any of the 4 reasons that are raised in our brief, this court should reverse and remand for further proceedings below. Thank you so much.